Yeah.
Hello.
Hello. Morning, Mark.
Morning.
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 Okay. Welcome, everybody. We can now start the Licensing Act 2003 Subcommittee. First of all, I will read out the opening statement.
Excuse me a second. Sorry, can I just stop you? Waiting for Gavin to come on. Is that all right if we wait for Gav to come on?
Okay, yes, certainly.
Yeah, just in case he misses anything. It's important or something. I've spoken to him, so he should be connecting anytime soon.
There's someone in the lobby, Mark.
Yeah, just let them in.
Okay, thanks.
There we go. Sorry about that. Thank you.
Okay, thank you. Licensing Act 2003 Subcommittee. Opening statement. Can I welcome all members and officers to the meeting of the Licensing Committee, which, due to government advice to practice social distancing, will be held virtually. The meeting is being recorded and will be available via the Council's website to be viewed as soon as practicable following this meeting. Please could everybody ensure that mobile phones are switched off or on silent mode. Members will have received an electronic copy of the agenda. I will ask officers to present a summary of the key points. For the record, the agenda can be viewed on the Bridgend Council website. Members and officers will be speaking at various points during the meeting, and those speaking may switch their cameras on at that point. But I would ask that, with the exception of myself as chairperson, at all other times you keep your cameras and microphones switched off, as this will help to minimise any background noises. If any member and officer wish to raise a point or question, they should press the hands up icon on the screen at the top right hand side of the Microsoft Teams window, and I will come to them in the order I receive the request. Please do not use your microphone until I invite you to do so. An officer from Democratic Services will be supporting the meeting and will be monitoring the use of microphones throughout the meeting. Before we formally commence, I will now ask the officer from Democratic Services to announce the names of the councillors in attendance at the meeting. I would also ask the officers and any other speakers to introduce themselves and when I invite them to speak during the course of the meeting. They too should ensure microphones and cameras are switched off at this point. Right, over to you, Julie.
Hello, my name's Julie Allams. I'm the Democratic Services Officer. Today in attendance, we've got Councillor David Lewis, Chairperson, Councillor Mike Kern and Councillor Tom Beadle. Thank you, Chair.
Thank you, Julie. Right, into the agenda. Number one, apologies for absence. Everybody is here. Number two, declarations of interest. I've got a, sorry about that. I've got a personal declaration, as I know both, having spoken to Mark and Gavin in the past, whilst having dealings with St Bride's Minor Community Council. Thank you. Any others? No. Three, Licensing Act 2003, Section 105, Temporary Event Notice, Rear Car Park of K2 Gym, Main Avenue, Brackler Industrial Estate, Bridgend. With that, I'll hand you over to Kirsty for the report. Thank you.
Thank you, Chair.
So on the 13th of August 2021, the licensing authority received a temporary event notice from Mark Holmes in the respect of the rear car park of K2 Gymnasium, Main Avenue, Brackla Industrial Estate, Bridgend. A copy of the 10 which was served can be found in Appendix A of your report. It should be noted that the premises itself does not have the benefit of a premises license. So the event is for Roots Shack to take place on the 28th of August 2021 between 1200 and 2300 hours. The maximum number of people at any one time to be present is 250. And the nature of the event has been described as: the event is called Roots Shack. The event compromises of a stage, bar and street food, and we will adhere to government COVID guidelines. So a copy of the 10 was served upon South Wales Police and the Council's Environmental Health Department. The Environmental Health Department submitted an objection notice in relation to a 10, and a copy of that objection notice was served on the premises user and can be found in Appendix B of your report. The licensing authority is aware that it is possible for the premises user and environmental health to enter into a period of discussion regarding the objections raised, and that Section 106 of the Act enables the modification of a 10 with the agreement of all parties. As of today, we are not aware that any agreement has been reached, and therefore the objection notice is to be treated as not having been withdrawn. So we have recommended today that the subcommittee is required to determine if a counter notice, which would prevent licensable activities from being authorised, should be issued. Thank you, Chair.
Thank you, Julie. With that, maybe Helen could come in and explain why the objection, please.
Yes, certainly, Chair. The applicant has had 3 consecutive events for the weekends of the 31st of July, 7th of August and the 14th of August, following which we have received a total of 5 separate complaints. Complaints were received after the first event, but the second temporary events notice had already been given the go-ahead as they submitted it before the first event had taken place. An officer from Shared Regulatory Services contacted the applicant after the first event to advise that we received complaints about the base, and it would be recommended that the second event was finished by 11. The applicant told the officer that the first event was live music and the second would be recorded DJ, so it wouldn't be so much of a problem. However, further complaints were still received after the second event. So it was agreed with the applicant then that the third event was amended to 11 PM finish instead of a midnight finish, and we would go out and monitor the noise ourselves. So on that last event on the 14th of August, we did monitor the event. I was also the duty officer on call for that day. So I received 2 calls from the operatives who take the initial calls. One was at 18:47 and the other was at 8:26 PM. So the level of base was monitored by Emma Aston on the 14th of August and was found to be intrusive both inside the complainant's property and outside in the garden. So the officer contacted Mr. Holmes to request that the level of base was lowered. He did do this, in all fairness, but it made no difference. It was still a nuisance at the complainant's property. The complainant was willing for Mr. Holmes to come and listen to the music at their property. So he met Emma Aston at the complainant's and heard the bass volume himself. So he said he would make further alterations. Then the officer then had to leave to go to another call out with myself. And then we met Gavin back at K2 Gym at just gone 10 o'clock. So what we did then was one officer went to the complainant's property and I remained at the K2 Gym with Gavin. And then the level of music was adjusted such that when Emma said it was okay at the complainant's property, I was then able to give Gavin an indication of the level at the gym that they could play it at. The problem was that that level was quite low for that type of event, and Gavin agreed that it's unlikely that they would be able to stick to that level. We did agree or discuss different types of mitigation on site, which they said they would take on board, but then on the Monday then, we had the application then for the temporary events notice for this weekend, but there was no measures in that to say what mitigation they would that would take place. So we objected, and then on the 19th of August, Mr. Holmes sent an email to Emma Aston to indicate sort of the things that they were thinking of doing. So Emma asked for more information, but we didn't get any more information back. So we've had to maintain our objection because of that reason.
Okay. Thank you, Helen. Mark, have you any questions for Helen, please? Or Gavin, obviously.
Yeah. First of all, on a couple of points that you made, the TENS was done on the Friday before the actual event of the weekend. So all the discussions we had on the weekend was after the TENS was done. The TENS application was done before the weekend, so that's why there was no information about what we could do and what the options. And also, then I sent an email last week regarding the options that we could do as well. So that was after the event. I did respond with an email, I think with about 5 options on the email, actually.
That's right. Emma sent me. Emma was unable to attend today because obviously she's on leave. But she sent me a copy of the email. So she sent me the email where you outlined a few options, and then she sent you a reply saying, "Please, can you provide us with further details?" And then she said she'd had no further communication after that.
Yeah, well, then we had the response from the council about the subcommittee meeting, so I thought we'd be discussing it in the meeting then. So nothing's been had. We haven't advertised the event. We pretty much cancelled the event this weekend due to everything that's going on. So I thought the subcommittee meeting would be a chance for us to all to speak and come up with a positive outcome, really. I've never sat in one of these meetings before, so I don't know how everything works, really. So.
Okay. Anything else, Mark?
No, that's it for now. Obviously,
okay.
we've done a response to the subcommittee, so I imagine everybody's got that as well.
Okay, Gavin. You haven't got your microphone on, Gavin.
Is that right? Hello.
Yeah.
Hi.
Fine.
Helen, how are you? All right.
I'm good,
Hi,
thanks. Yeah.
Yeah. Helen, when you took the reading with myself at 10 o'clock at the place, wasn't it?
Yeah.
At the shack.
Yeah.
How was Emma monitoring the sound levels at the premises?
It was subjective. So, it was subjective. So she basically went in the garden and listened to how intrusive it was, and at when we asked you to turn it down, it was turned down to a level then where it was no longer intrusive at the complainant's property, so we could give you a reading at the K2 gym, so you could monitor the noise levels from there, because obviously at any time that you're going to be doing the event, you're not going to be going into the complainant's garden. So what you needed was a level at the music event, so you could easily monitor it not to exceed that level.
No, but the way I understood the night, the time we spent together, that I don't think it was ever recorded at the complainant's property with the meter, was it?
No, it wasn't. So the officer went there and listened to it subjectively, and and she was telling me that no, it still needed to be turned down. So you turned it down to the level to where it was still audible at the complainant's property, but no longer a nuisance. And that then I was able to give you the corresponding noise level from the sound level meter at that point.
Yeah, but in the last email Emma sent to us, she said between 65 and 67 decibels, which I thought was an objective statement, but clearly it was subjective.
Yeah, at K2 gym. At K2 gym, it was between 65 and 67.
Yeah. Okay. Not at the
not at the complainant's premises, no.
So what are the allowed decibels at the complainant's property then? We need to know that, really, so that we can make these changes, so that we can make the event go ahead, isn't it? Because
if the if it was between kind of 65 and 67 at your premises, then given the distance of where the complainant lives, it's going to be around 35, 36 decibels at the complainant's property.
Okay.
But the level that we set for you is the level that you're going to be able to monitor at your gym, because you're not going to be able to keep going into a complainant's premises to take levels from the complainant's property.
Yeah, but if we can do the changes to absorb the sound, it's best that we use the meter at all places, isn't it? So that we've got a objective.
Well, you'd be able to go to the closest property of where that was and measure outside, wouldn't you? But...
yeah, because obviously we don't want these hassles, you know, and we don't want people to be disturbed either. So if we can put all these things in place and we can know objectively with those meters what the sounds are and what we have to hit, we can make those necessary changes, no more or no less, you know, otherwise might cost a lot, you know, and we're doing over egging it. So
yeah, but the issue is at the moment the noise, the corresponding level that was given to you at the K2 gym was sort of in situ with what you had there. So but you know, you said you wouldn't be able to stick to that level, and I agree, it did sound low at the K2 gym, but it had to be that level not to cause a nuisance at the complainant's property.
Yeah, see, I think there's a mistake here, Helen. I think Emma was referring to the 65 and 67 decibels at the complainant's property. That's the way I understood it. No,
she because I clarified that with her, and I was there at the time, and the 65 to 67 was what was being measured at your premises, not other complainants.
Yeah, well, if it's 30 odd decibels at the complainant's property, that's hardly audible, you know.
Well, that was the level at which it wouldn't be a nuisance.
Is it? What? Okay. I've got a chart.
And that's and the base, and of course the base frequencies have to be, you know, that's the overall noise level. What you've got to be careful of is the base frequencies, because it's the base that's causing the main issues. So that's with so that level was with a lot of the base already taken out of it.
Yeah. Okay. Thank you.
Thank you. Mark, you've got a further question?
Yeah, I just don't understand the acceptable levels in my head, because obviously there's charts, there's that measures all the decibel levels and what are acceptable, and what I've read is acceptable. So I still don't understand, don't have a clear understanding of what's acceptable in somebody else's property, you know, as a sound level.
Well, it's all based on statutory nuisance. So sort of the, you know, how loud it is at their premises, and it was clearly intrusive on when we monitored on the 14th. You could do it inside the living room, inside the bedroom. You could do it in the garden. So in the garden, it would have been an issue during the daytime. In the evening, it would have been a problem even inside the premises as well. So that's what we go on. And then in order for it not to be a nuisance, we give you the corresponding level that you have to achieve at K2 premises. But obviously that's not at the level that you want to play at. You want to play it louder than that. So unless you put kind of mitigation measures in place, which we asked you for further details on, but you didn't submit, we can't go on anything else.
What further details did you need?
Well, you give where is it? You sent an email to Emma with 5 different points that you could look at to reduce the noise levels.
Yeah.
And you said this is what we're thinking of, or perhaps a combination of all 5. So Emma said, and you asked what level needed to be achieved. So Emma told you the level that needed to be achieved at K2 gym. And then she asked for further details on what mitigation you were actually going to do. And then she didn't get any further emails back.
Yeah, no, we haven't had a level. We haven't had a response. We asked what's an acceptable level, and we still haven't had a response.
You did get a response because Emma sent me a copy of the email.
Oh.
And she asked for further details.
I'll read the email. 1 second. I'll just mute a minute. I'll get the email. 1 second.
Chair, I got my hand up.
Yeah, I realise that, Tom. I'll be coming to you next.
You sent the email at 9:35 on the 19th of August, Mark, and she sent you a response at 11:01.
Oh, sorry, I was muted then. Sorry. The question was on that email. What also would be helpful is to know a concrete measurement that has to be achieved or not exceeded at the complainant's property. Yeah, I never had a response to that question.
She did send you a response, Mark. She said, "Dear Mr. Holmes, thank you for your email. With regards to a noise level, the level that we measured on 14th of August 2021 was between 67 to 65 dB at the premises, as in the K2 gym premises. Yeah. When do you think that you will have these, because you sent an email about the measures, when do you think you will have these measures in place? I can arrange to come out and check whether these measures have been effective enough to resolve the issue with the base." And she never had a reply to that.
Yeah, and then we had
that's why we objected.
Yeah, this is why we had the meeting then. But I asked a specific question for the at the complainant's property, not at our premises, at the complainant's premises.
Well, I can tell you that between 65 to 67 dB is going to be around 36 at the complainant's premises, but you're not going to be able to measure at the complainant's premises unless you measured outside. But she never had, she's told you between 65 and 67 at the premises for K2 gym, and she never had, she asked you for information regarding the details of what, additional details, and you didn't respond to her.
Yeah, because we were having this meeting to discuss.
Yeah, well, the whole point was to try and sort it out before the meeting.
Is it? Oh, is it? Yeah. I thought that's what I thought the meeting was about. I say I've never had this situation before, so this is new.
Okay.
Okay. No. Mark, if you had contacted the department beforehand, you could have sorted it out, and we wouldn't have needed this meeting. But anyway, we'll continue now. Councillor Tom Beadle next, please.
Yeah, thank you, Chair. It's just a point that was raised by Mark earlier on, where he said you'd cancel the event, and then I wondered why we, as a licensing committee, are actually looking at this application when you've said that it is cancelled. But obviously, we shouldn't enter into this debate between the applicant and shared regulated services about noise levels, because that should have been resolved before the application was submitted. So that here we are today, and we find that it's a meeting that we did not need to attend, as you just said, so that the applicant should have sort of got in touch with Shared Regulatory Services to make sure that they had the precise readings for noise levels, etc., before the application was submitted. So that was the point I'm making, Chair, that it was an unnecessary meeting that we've had today, but we shouldn't be entering in, or shouldn't be allowed to enter Shared Regulatory Service with the applicant on noise levels, because that's for another meeting, not for us.
Right, can I just come in there then, Chair? So can I, to the applicant, is the event, are you intending to proceed with this event that you put the temporary event notice in for?
I know this event, no, but we will be putting, we would like to put other 10s in, because we've
so
invested into the...
This is, okay, all right, this is a formal licensing committee who makes decisions on licensing law. So when you put your temporary event notice in, if there's any objections, it then comes before the committee and they hear it and they decide whether that event can proceed or not by either deciding to issue, to stop it by issuing a counter notice or not to stop it. So there's little point in proceeding with the committee today if you're not proceeding with the temporary event in any event. So are you withdrawing the temporary event notice?
For the 28th, but we would like to do other temporary events notices in September and October.
But we can't determine that here now because you haven't put the applications in. So that will be basically based on the when you'll have to put your application in then, and if anybody objects, i.e. Public Protection or the police, then there'll be another committee here, and this is a formal committee here and who decides on the law. So it's not just a little meeting where people discuss things. It's a meeting where councillors will make the decision on your temporary event notice applications.
Okay, can we make a decision on the 28th? Because it's still there. The application is still there.
Yeah, the application is still there. So you're saying you want to proceed with the temporary event notice?
Well, proceed with an outcome, if that's possible.
Well, your application is still live, obviously, and there is an objection. So the committee here to sit, so they can make a decision on whether your event can go ahead on the that you've made the application for, but it will just be for this event. Any future events, obviously, if there are any objections, the committee will sit again. But of course, you don't need a temporary event notice for live music in any event. So it's only for the recorded music.
Well, so if we had bands, you don't need a temporary events notice?
No, not for bands.
What about a bar, though?
Yes, you would need them for the bar. Kirsty, can you come in on there and explain what the...
Yeah. So you need a temporary event notice to cover the alcohol and any recorded music that you want to play and any live music after 11 p.m. So if the pollution are objecting today to the regulated entertainment, what they're objecting to is the recorded music, because live music is deregulated between 8 a.m. and 11 p.m.
So you can, in other words, you can play live music between 8 a.m. and 11 p.m. without needing any form of a license or a temporary event notice. That's what the licensing officer is saying.
Okay, but if there was a complaint of noise, what would that outcome be?
Well, that would be up to the noise department then, whether they wanted to issue an abatement notice against you, which is a whole other matter.
I can confirm that if you went ahead with live music and you were found to be causing nuisance, we would serve an abatement notice.
Okay. Could I have some clarification on nuisance then, please?
In what respect? What do you want to know?
What do you class nuisance as? Because temporary events notices we're only allowed 21 a year, which classes at 5.75% of a yearly. So 94.75% of the year we're not going to be there. We're not going to be providing music. We're not going to be doing anything. So that to me seems like quite a large absence of sound level to not cause a nuisance.
No, when you class what is a nuisance, you take into a number of factors: frequency, duration, time of occurrence, the noise level. So you could still have an event that causes a nuisance if it occurs once, but if it went on late or if it was so intrusive and the noise levels were so unreasonable. So it depends on a number of factors. We take everything into consideration when we determine what is a nuisance, and we look at case law and everything as well. So
right, so we are wandering off track now here, because this obviously that's a matter for the Public Protection Department in future, what they decide to do depending on what the decisions are on your temporary event notices. So for the purposes of today, the committee will just take into consideration obviously the objections to the temporary event notice and the evidence given by Helen, and obviously any representations that you want to give, and they will decide then whether they will issue a counter notice or not. So the abatement is obviously a side issue for you and Public Protection in the future. So basically, have you got any more questions to ask of Helen? And then if not, we move on to your case. Well, you will make your representations about the event going ahead to the members of the committee.
No.
Chair, perhaps you could ask if any other members of your panel want to ask Helen any questions before the applicant gives their case.
Councillors, any questions, please? One thing I'd like to clarify, have all the previous events been held in the same venue?
Yes.
They have, right. Okay, over to you, Mark and Gavin.
Gav, you go.
Yeah. Oh, sorry. I was just going to confirm something with Helen quickly, if I could, sir.
Okay.
Helen.
Yes.
So we can confirm for the record, today that it wasn't. It was just a subjective view of the sound at the complainant's property. It wasn't an objective one.
No, we didn't take measurements at the complainant's property.
So you just decided if it's a nuisance by ear. Is there a decibel level?
Yeah, to bring it down to terms. We listened to the noise and it was very intrusive and it would have been a nuisance.
Yeah, but you don't have a decibel level that we have to hit at the complainant's property.
Well, we've given you the level that at your venue. If you were to do a calculation of what that level would be at the complainant's property, you're talking around about 35, 36 decibels.
That's lower than talking, Helen, that is. You do know that.
We've been through this at the venue, and again, it's not for us to argue about what is speech, levels of speech and things like that. The event was monitored on the 14th. It was clearly intrusive. The bass was an issue.
Helen, if you know what we can't have it at, you must know what we can have it at.
I just told you.
We understand what we can achieve.
I just told you what it needs to be achieved.
No, but all these absorbers that we put in, to dampen the bass will obviously allow us to have it louder at the property. So
yeah, but I haven't got any. You haven't submitted any information as to how much that will attenuate the noise. So unless we have that information, I can't give you that. You didn't submit any further details. You just said you would put sound absorbers in, hay bales, lower the bass, but you didn't say where it was lowered to. You didn't say how thick the structures were going to be, how much noise that would absorb. So until we get that information, I can't give. Emma asked for those details, and they weren't.
So Helen, respectfully, you know what thickness absorbers we need for the sound system that we have.
No, it's not for us to tell you exactly what you do, because it all depends on sort of how you build. At the moment, you've got like an open metal frame structure with effectively a bit of tarpaulin over, so it's like being out in the open air. So I don't know how good a structure you're going to be building, how thick. There's different in thicknesses of insulation material, so it's down to you to submit details to us. We're more than willing to work with you to get to a level once you submit all those details. But for this committee, you hadn't submitted sufficient details. We witnessed a nuisance the previous week, and we had to object to the temporary events notice. So, and that's where we are. So I'm more than willing, and Emma as well, to meet with you work through any issues, but that's not for this committee right now, you know.
Could I suggest to Mark and Gavin that I think it would be more beneficial now, rather to carry on the discussions here. As you said, it's cancelled on Saturday, so I think it would be more beneficial if we all went away and both Mark and Gavin worked closely with Helen to come to some resolution on it.
Yeah, we're happy with that. Perfect.
Yeah, more than happy with that.
So we're back now again to the point. Are you proceeding with this application?
No, we leave this one, isn't it, Mark? Because obviously it's got the wrong energy about it, you know, and it's too close to the date now as well.
Okay, so can you confirm for the record, please, that you are withdrawn in your application?
You happy with that, Mark?
Yeah.
Yeah.
Okay. Thank you.
This is sorry that we got you. Well, you called the meeting, but you know, it may be a mistake. So
yeah, sorry. The law. You see, this is strictly governed by law. It's the Licensing Act 2003. So we didn't have any option but to call the meeting. You see, because the law says that once you put in a temporary event notice, if there's an objection, we have to list a meeting, a committee hearing. So that's why it's been listed, because that's what the law says we have to do, you see. And then the three members who sit will listen to the evidence from both sides, and then they'll determine the temporary event notices, whether to issue a counter notice, which means you couldn't proceed, or not to issue a counter notice, which means you could proceed. So that's the basis. So every time you file a temporary event notice, if you get objections, it'll always be listed before the committee to make a determination if there are objections. The reason why your previous ones went straight through is because obviously there was no objections.
yeah, and this license was put in prior to all this talking, so that's the problem. You know, that's why.
So if you would entered into discussions with the SRS prior to the hearing and come to some resolution, then obviously the event, you know, the members would hear that and say that you've come to an agreement now. But obviously that's not the case, and then they would have to determine, based on if you were proceeding with this application, they determine on Helen's evidence and the representations that you make today. So, but obviously, if you withdraw in because you're too close to the time now, then obviously that brings the committee to an end.
Yeah. So if we work along with Helen, that's okay with everyone, is it? Is that all right?
Yeah. Fine.
Yeah.
Is that all right, Helen?
Yeah, that's fine, Gavin. That's no problem.
Yeah. Well, thank you for your time, everyone. Anyway, so.
Okay,
Yeah,
thank you for
you.
attending. Okay, Chair, can you formally bring the meeting to an end, please?
Yes. With that, I close the meeting. Thank you.
Thank you.
Thank you.
Okay, thanks. Bye.